Hello guys, welcome back to the channel. I am Prakriti and today we are going to move further with our remaining general defenses. In the last video we have covered three general defenses which were voluntary non-fit injuria, plaintiff the wrongdoer and the inevitable accident. Let's get started. The next general defense is act of God. Act of God or vis major or force major may be defined as circumstances which no human foresight can provide, against any of which human prudence is not bound to recognize the possibility, and which, when they do occur, therefore, the calamities that do not involve the obligation of paying for the consequence that results from them. The act of God is a defense used in the cases of torts when an event over which the defendant has no control occurs and the damage is caused by the forces of nature. In such cases, the defendant will not be liable in tort law for such inadvertent damage. According to this defense is provided in the case of natural calamities or to the cases when there is a natural force applied, means a human which do not have any control over that particular thing, that is act of God. A normal human, a prudent human cannot foresight a particular thing which is going to happen or not going to be happen because of the act of God, because of the natural force which is applied. In this case, the tort law, according to tort law, this general defense of act of God is applied, in which the defendant is not to be held liable. It is a kind of inevitable accident, with the difference that in case of act of God, the resulting loss arising out the working of natural forces like exceptionally heavy rainfall, storms, tempests, tides, and volcanic eruptions. Because in this case, all natural forces, a prudent human cannot foresight that all these things are going to be happen. Two important essentials are needed for this defense. First, there must be working of natural forces, and second one is the occurrence must be extraordinary and not one which could be anticipated and reasonable guarded against. To apply for this general defense of act of God, there should be two important essentials. Firstly, there must be natural force applied, and the second one is the natural force should be that extraordinary that it cannot be anticipated or reasonable guarded. That just suppose that you say that rainfall is a natural force, but it can be guarded, and a normal rainfall can be guarded. It will not be a reasonable ground. The next private defense is the law permits the use of reasonable force to protect one person's or property. If defendant uses the force which is necessary for self-defense, he will not liable for the harm caused thereby. To use this defense, there are three conditions need to be satisfied. It is a general defense. We all must be heard. It is a very common defense, that is private defense. In this case, the law permits reasonable force. The person should use reasonable force to protect one person or his property, and if the defendant uses this force, he will not be liable for the harm caused thereby due to that reasonable force. There are three essentials should be there to use private defense. The first essential is there should be an imminent threat to the personal safety or property. For example, A would be justified in using a force against B merely because he thinks that B would attack him someday. Nor can the force be justified by the way of retaliation after the attack is already over. So, according to this essential, there should be an imminent threat. One should not say that this person is going to harm me one day. Just given an example that A would be justified in using a force against B. A would not be justified. You can't say that one day B is going to harm me, so today I harmed him to stop for being harmed for a private defense. No, it is not a reasonable ground. It is not an essential. Or he can say that B has hit me, that's why I apply this certain kind of force. But the attack has already happened. It was not immediately necessary for that particular time to apply that force. The second essential is the force that is used is absolutely necessary to repeal the invasion should be used for, and the amount of force which is applied is just equal to repel the invasion. That just suppose that he has used a particular amount of force to attack some B, then B is should apply that particular amount of force that could protect him. The force used by the defendant should be in proportion to the act committed and enough to ward off the imminent danger. It should not be excessive and not must be out of the proportion to the apparent urgency of the occasion. Just suppose that A strikes B. B cannot justify drawing his sword and cutting off his hand. Just suppose A want to slap B. So he is about to slap B. So B cut off his hand by the knife or sword, whatever he had. No, it is not a particular desired amount of force which should be used by B. B could stop his hand by slapping him back or holding his hand, but cutting off A's hand is not a good decision. It will not amount to private defense. The next general defense is mistake. Mistake, whether of fact or of law, is generally no defense to an action for tort. When a person willfully interferes with the rights of another person, it no defense to say that he had honestly believed that there was some justification for the same, when in fact no justification existed. Entering the land of another thinking that to be once is trespass, taking away another umbrella thinking that to be once on, and injuring the reputation of another without any intention to defame or is defamation. In such situations, the defense of mistake cannot be taken. According to this, that mistake, whether it is of fact, there are two kinds of mistake: mistake of fact or mistake of law. Mistake of law is just not right, because according to a legal maxim, that is ignorantia juris non execusit, means that ignorance of law is not excusable. But mistake of fact is generally no defense to an action of tort. When a person knows that this is wrong, but he interferes with the right of that person, that is not a defense. There are three examples: that entering into one's land, that amounts to trespass, but saying that by mistake I have entered it, that is not a good defense. Taking away another's umbrella thinking that one's on, one should realize that he should check before taking the umbrella of another. The third, by saying something about another, hurting the reputation of another without any intention. He was not having any intention to defame the other, but the other's reputation has been injured. So that the defense could not be taken in this case. The next general defense is necessity. An act causing damage, if done under a necessity to prevent a greater evil, is not actionable even though harm was caused intentionally. Necessity should be there distinguished from the private defense. In necessity, there is an infliction of harm on any innocent person, whereas in private defense, harm is caused to the plaintiff, who himself is the wrongdoer. Necessity is also different from the inevitable accident, because in the necessity the harm is intended, whereas in the inevitable accident the harm is caused in spite of the best effort to avoid it. Throwing goods overboard a ship to lighter it. For saving the ship or person on board the ship or pulling down a house to stop a further spread of fire is a common example of necessity. According to this general defense, the necessity, an act of causing damage if done under a necessity, that it was the need of the time to prevent a greater evil. It is different from necessity is different from private defense as well as from inevitable accident, because in private defense the harm is caused to plaintiff, which was caused by the plaintiff who himself was a wrongdoer in the private defense, but in the necessity the plaintiff is not the wrongdoer, and in the case of inevitable accident the harm is already caused, but in the necessity the harm is prevented. It is in spite of best efforts to avoid it. In the case of inevitable accident, the damage has been already caused, but in the necessity there has been an effort to prevent the greater evil. In the example that Cobb versus Shape 1891, in this case the plaintiff house was burning, it has catches fire, but later on and the defendant get into his boundary to stop the fire, but the plaintiff sued the defendant for trespass, but the court held that the defendant was not liable for trespass because it was a necessity to stop that fire. In the similar case, that is Carter versus Thomas 1891, in this case it was not the necessity for the defendant to get into the boundary of another person to stop the fire, because the fire was not that severe and the persons there was present there, so they could stop the fire. So in this case the defendant was held liable for the trespass. The more example for necessities are throwing goods overboard a ship to lighter it for saving the ship or person on board the ship, or pulling down a house to stop a further spread of fire is a common example of necessity. According to next general defense, that is statutory authority. When an act is done under the authority of an act, it is a complete defense and the injured party has no remedy except for claiming such compensation as may have been provided by the statute. The damage resulting from an act which the legislature authorizes or directs to be done is not actionable even though it would otherwise be a tort. Example: if a railway line is constructed, there may be interference with the private land. When the train is done, there may also be some incidental harm due to noise, vibration, smoke, emission of sparks, etc. No action will be taken either for interference with the land or for incidental harm, except for the payment of such compensation which the act itself may be provided, because the construction and use of the railway are authorized under a statute. Means the act which is done by a party and which cause harm to other party, but the act is done under a statute, that in that case the compensation is provided to another person, which is not a defense but the person saves, because he can use the general defense that he is working under a particular statute. Such the example of railway has been taken. In this the private land has been taken, but the compensation to other party has been already provided. However, this does not give the authorities the license to do what they want to do unnecessarily. They must act in a reasonable manner. It is for this reason certain guidelines need to be followed during the construction of a public transport facilities. But also in this general defense, that these statute authorities also should work under a reasonable manner and under a reasonable ground. They should not work in arbitrariness to apply for the general defense of statutory authority. Thank you so much guys for watching this video. If you like this video, please hit the like button, and if you want more videos such like this, please subscribe to the channel and also hit the bell icon.